So I noticed that Catherine Anaya is over in the corner with the tequila, becoming an American with disabilities. But in fact, it's a totally different subject when you're talking about having a disability that you have to sue in order to be accommodated for. And that's one of the reasons why it is that Lindsay Leavitt is here, attorney at Jennings, Strouss, and Salmon. A tidal wave of lawsuits on this Americans with Disability Act, and yet, to tell you the truth, most of us probably thought that was resolved years ago.
Well, the Americans with Disability Act was enacted in 1990, but there have been some new regulations and proposals that have come out from the Department of Justice in 2010, and it's those new regulations that these new wave of title suits are reacting to.
Give me a couple examples of the new regulations.
Sure. So one of the new regulations is a hotel or any public accommodation with a pool must have wheelchair accessibility to that pool. And so, for example, a hotel must install a pool lift that someone in a wheelchair could use to gain access to the pool. Over 150 hotels in Arizona have been sued by one plaintiff because they lacked a pool lift.
Sounds expensive for the hotel.
Correct. To purchase and install a pool lift, it's $2,000 to $3,000. But when you factor in the cost of litigation, of paying the plaintiff's attorney's fees, which is standard under the law, it can get expensive in a hurry.
But regardless of the number of ramps that have been built and the number of elevators that are available now that weren't available before, and all of those things that are just and right, won't there always be inequality?
Well, I think a lot of disabled people feel that way, and that's why these serial plaintiffs, there's only a handful of them here in Arizona, and they've filed over 260 lawsuits in the last 9 months.
Are they in the right, or are they just troublemakers?
Well, it depends who you talk to, I think. But for the most part, what they're alleging is true. A lot of these mom and pop businesses are technically out of compliance with the law, but on the other hand, a lot of these mom and pop businesses say, well, you didn't have any intention of even visiting my accommodation. You didn't come here to sample the goods and services. You came here specifically to look for accessibility issues, and that's the only reason you're filing.
And we know that there are those serial filers in almost every field. But on the other hand, and the other side of the issue, aren't there also overt violators who are just ignoring the ADA rules?
Oh, I think there certainly can be. I think part of the problem, though, is awareness of these new 2010 standards. A lot of these mom and pop businesses, Pat, don't have in-house lawyers, don't have in-house compliance departments that can advise them of what the new laws are, of where a soap dispenser needs to go in the bathroom, of how a mirror needs to be lowered, how a urinal can't be higher than 17 inches off the ground.
Well, what is your firm doing?
Our firm is defending a lot of these businesses and helping these businesses and advising these businesses on how to get into compliance with the ADA as quickly as possible, and settling these cases or defending these cases as quickly as possible for as little money as possible.
All right, but is it going to be expensive if we have, for example, a mom and pop business, an independent firm here in Arizona, picking up the phone right now to call your office just simply to find out if they're in violation?
No, me specifically, no. I'm happy to give a free consultation and give them general advice.
Ooh, wait, did you hear that? Attorney, free, big law firm.
Don't tell my bosses I said that.
Jennings, Strouss, and Salmon. Shh, it's okay. His name is Lindsay Leavitt. I'm Pat McMahon.